I don't know. I know
it's not my news to tell. So.
I know he was interested. I don't know.
I know he interviewed. I just don't know the decision, and I don't want to.
He was working for him like over the summer.
Yeah, last semester.
Okay.
Yeah.
I'm totally not surprised at this.
He was in my section first year, but I like rarely see him since then.
Do you think that means no?
I thought it meant no, but then I talked to some people who and they just thought it was a yes. So I don't know. I didn't know if he was in section 2 or 1, but I just wanted to know him like last semester and stuff.
He's a nice guy. He's really smart.
He's really nice. He works really hard.
Yeah.
He's like the executive editor for already, and he does a lot of stuff.
Do you have a picture of him?
He's on Facebook.
As a DU grad, I hope you would like
I know,
find
that's what
somebody
I
for
was.
DU.
Yeah.
I feel like that would be a really good fit.
Well, because I know he interviewed 2 DU grads that are currently working on the Court of Appeals. So yeah, you would.
That's tough. That because you've got people with experience already coming in.
Yeah.
Interesting.
I like your jacket.
Oh, thank you. My sister gave this to me for Christmas last year, and I forgot about it, and I found it in this like Tupperware container under my bed, and I was like, oh.
That's so fun. I don't like spring cleaning. And then you do, you like forget about it.
Every single year, and I end up dropping it when I don't need to.
I feel like I don't even want to review my PT.
That seems so
That's
long
normal.
ago.
That's very normal.
I feel like that's nothing.
Well, we'll talk about it a little bit. Yeah, I mean, there's no, Okay, Kira. I got your name down. I'll be a little bit better after we meet a few times and when we meet individually. So, it says here, Allison Blonde.
A what?
Blonde?
Blonde?
And you're Allison? No.
Who says that? Who said that?
You're Alexis.
I'm Alexis.
It's probably hard with so many
She's
students.
blonde. It is totally so many students, let me tell you.
And then 2 like Bills, and then Kyler and I were both K's, but then Kyler left me and so
And
now
you
I'm
look so
alone.
much alike.
Yeah, well Kyler and I do look alike also, which is a problem.
And you're Bill.
I am.
Okay, great. You wouldn't characterize yourself as blonde?
Oh no, I take that as a compliment.
Okay.
I used to be blonder, but I've gone darker.
Isn't that the way? Okay, we'll see if Bill makes it today. All right, so we're going to go over that PT, and then we're going to have you guys sign up for conferences so we can talk about it a little bit more individually. But I hope I stressed enough in my email that you should have very low expectations for your performance, especially on the first PT. So, and it's kind of, in some ways it's a little bit of an eye-opener, right? So you realize that on the day of the bar exam, you will have to produce competent, work product under those circumstances. So you'll have more time than you had last week. But it's also ultimately should be confidence producing because you guys will totally get there, right? So from where you're standing now to the day of the bar exam, you're going to acquire very efficient technique for dealing with these. But this PT also, because it's set in a judicial context, gives us a little bit of, it overlaps substantively with the discussions we're having in the course. So we'll take a look at that. Yeah?
Does DU, I know that everybody takes, or not everybody, most people take a bar prep course. Does DU do anything, because I know there was like the summer preview and they're doing LAS now.
Yeah.
Do they do anything
during
the summer?
Yeah, so both the summer and the winter or the spring, actually, and I'm involved in that as well. So it's actually really pretty comprehensive and excellent course that is an overlay on top of whatever your commercial bar course is. Mm-hmm. So it's bar success. And there's a lot of different models for bar support programs, but the way the DU does it is, we have a schedule throughout the course of the 7-8 week bar preparation period. And so if you're learning contracts in your commercial bar prep course, we'll have a hour and a half to 2 hour session on strategies for approaching contracts essays, and then you'll do an essay, and then they have this whole team of writing advisors who individually review your essay and give you feedback. It's really kind of, hey there, state of the art, and so far beyond what most schools do. you know, so the individual feedback is really good. So I do some individual feedback, I teach some sessions, but then my role primarily is to do one-on-one meetings with graduates. So you get a lot of face time as well as a lot of written feedback. So it's a great program. And it just sort of, it does what the commercial programs don't do, which is really tell you how to, not just the substantive information, the rules of law, but how to perform well on the bar exam. So it's something you definitely want to take advantage of. All right, let me do a little, and what I'm going to do is kind of annoying, but every time I talk to you guys, I'm going to use your name. So that'll help me. So it probably was just lackadaisical because there are so few students. I was like, oh, okay, I don't need my usual tricks.
Bill gets a C.
No, it's good, believe me, it'll be heavy-handed. And then we're going to start our conversation about ethical standards that are related to being a judge, being a law clerk, and to judicial opinion writing. And again, rereading that article on ethical judicial opinion writing, it's really fantastic. It's a tremendous resource. It's something I would definitely hang on to. There might be some room for disagreement about certain issues, but it really flags the issues in a way that, until you start your clerkship and start working with some of these questions, it's kind of hard to anticipate exactly what it means to write an ethical judicial opinion. So hopefully we'll keep coming back to this throughout the semester in terms of guiding our efforts to draft the opinion and whatnot. But I also like it because I read it and I see things that I have said as if they were true for a very long time, and somebody else says it too, so that's sort of gratifying. So that's basically our goal for today, and then we're going to continue our discussion about judicial ethics, especially in opinion writing, next week in the context of two of the particular decisions of the United States Supreme Court that have been criticized as I don't know how to describe it exactly, but but were ultimately overturned and seen as problematic even the day that they were decided. So let us start with looking at this performance test. And what I did, so I'll give you guys back a copy. I don't know if you see your handwriting, you can pick out that copy. Doesn't really matter. And then this is what I was able to produce in the time that we spent, which was really a total, I think, about 70 or 65 minutes. It's substantially less than what you actually have for the performance test, okay? So first of all, outside of shame and humiliation, what were some of your other subjective experiences taking the performance test? Bill. See, I just did that.
I had a hard time. I was sort of drawn to the confrontation clause issue.
Okay.
And
you guys can hang on to the packets.
I think that's the way it is.
Okay.
I don't think I took it.
So you saw that there were multiple issues, and you kind of.
So I started in the wrong place. I was,
okay.
Since with our discussion before it, I was worried about doing the law. I didn't get to any application at all.
Okay.
So I started doing this whole confrontation clause thing, and then, the way through the problem, I thought, well, I'll just spin out the Rule X for confrontation clause.
Mm-hmm.
And then, there was a much simpler way through the problem where I wouldn't have needed to do nearly as much of that as what I did.
Okay.
So it was poor planning, and I needed that outline a lot more thoroughly before I just started writing stuff.
Okay. So that goes to an issue that will come up also in your clerkships, which is how to order issues properly. Of course, the clerkship, you're going to have a lot more time generally to do that, but you want to develop an instinct for how to properly order issues and see the relationship between the issues as well. So you mentioned that if one particular issue had gone in a certain direction, that might have saved you some work, right? And so you just felt rushed, you think?
I just felt confident with the confrontation clause stuff.
Okay. That's a good reflection.
Like where I thought, I could just sort of write the Rule X without looking at the law, so then I could just do that and then come back to the other and fill in.
Okay, okay.
I thought that would be more efficient, but
Okay.
then it ended up being not that necessary.
So what's the takeaway? What's the lesson that you learned from that experience?
I think in the performance test context, there's, it's a lot about, well, in all of our tests, there's the, the scope of the question issue, but then,
What was your sort of knowledge position with respect to the law presented here? And how did that influence your process?
I was much more confident with the confrontation clause stuff than with the hearsay, top of mind than with the hearsay evidence issues.
Okay.
So I thought I would write what I was confident with and come back to what was weaker and fill in.
So it's sort of like a path dependency almost, right? So you have a certain area you're more familiar with, and that kind of it creates a bias in a sense on how you approach it. So what would be the ideal in sort of contrast to that approach?
Well, in contrast, I mean, to use the majority of the time on what I felt most insecure about.
Okay.
And get that done, and then fill in with the time I had left with what I was most confident in.
Okay. Okay. So don't turn away from things that you have uncertainty about. That's different. Get in there, grasp it, work with it. Kira, you had a point?
Yeah, mine kind of was similar to Bill's, but I was more comfortable with the evidentiary issues than the confrontation clause, but to me that made sense to address them first.
Okay.
So I was like going through them, and then when you called time, I hadn't even gotten to confrontation
Okay.
clause. But then when you were saying that if you said it was dying declaration, then that got rid of the confrontation, I hadn't yet recognized that, and I don't know if I would have. I might have if we had more time.
I suspect so. I mean, you guys were really limited on time, so I think that probably. The thing is with the PT is that a lot of the insight doesn't really come till the very end, right? So you're kind of working with these raw materials and shifting them around, and you don't even necessarily know what you're doing until maybe the last 20 minutes or so. So I think that's not an uncommon experience. Will?
So I kind of started, and then I thought I had a pretty good understanding of the issues. And I set them up kind of similar to yours. I ended up splitting them apart instead of doing just the two that were in the motion.
Okay.
And I don't know if I didn't analyze everything, so I don't know if that really would have helped having them split or not. But I did that, and then I was like Kira, I felt better with the evidentiary issues, so I thought I'd start there.
Okay.
But then I read through it, and well, part of me, like the relationship between the issues, I thought was something that I was kind of like leery of where this is going to go.
Yeah, and that was one of the more complex, parts of this substantively.
Because I wasn't sure if like the confrontation clause would kind of like preempt even getting some of the evidentiary stuff, and so like kind of the bill, I thought maybe that'd be something that would go address first because it almost clear out the evidentiary issues. But then in this case, it was almost the opposite.
That's correct, right? That's
where
correct.
it's set up, you looked at the evidentiary issues, and that set up how you analyzed the confrontation clause. And so I'm starting to get there, but then, I don't know how far I got, but.
Okay. And so one thing I think that I'm kind of hearing, it's causing me to reflect on is sort of the idea of humility in the face of the law. So we do, you guys know a lot, especially after you study for the bar exam, you're going to know a lot, right? But every time you sit down with a legal problem, it's like, okay, I have to really start from scratch in terms of understanding what's in front of me and being open to learning the relationship between these issues and things like that. So you feel like you can get ahead by bringing some of that background knowledge in, but sometimes it actually confuses the matter. So Allison?
Well, I think my biggest oversight coming off a very stressful day of work is I didn't just flip through the whole packet. And so I got really deep into the trial court decision and how first I thought, okay, the best way to frame this is to start with the rules. So here are the rules that bear on the issue. Lay out the rules, general rule statements about the rules, and then fill in with the cases afterward about how they modify or sort of expand on or add nuance to the rules.
Okay.
So I got through the
To the evidentiary rules.
The evidentiary rules.
So maybe
sorry.
an overemphasis on the evidentiary rules.
I think so. And that may have just been my own personal recent experience. I took my evidence final last semester and so focused on that.
Yes,
so
yes.
I think I was somewhat limited by the mentality that I was still in. I just did not.
A couple of you have kind of pointed to that as sort of a little bit of a bias, cognitive bias. Yeah.
I just did not register that the second case was a higher court case. I sort of like looked at it and was like, okay, that's a confrontation clause case. I'll look at that one when I get to the confrontation clause.
Okay.
And then I went deep into the trial court opinion, and I really should have started with the opposite. So I think
Okay.
I definitely limited myself and ran out of time because of the approach that I took.
Okay.
But there was not a whole lot of thought that went into it.
Yeah,
so I'll admit
that's
that.
right, that's right. And again, that's part of the reason why we're sitting back and reflecting on it now. But I think that the lesson there is sort of the idea that you need to look at the totality of the legal universe before you start trying to solve the problem, right? And again, that is true whether it's a 90-minute thing, whether it's a 9-week issue, or project that you're working on, is to really gather everything that's relevant in terms of legal issues and have a thorough understanding of that before you embark on applying any one of those issues.
I think it definitely hit home for me too. My research style is very specific in that, like, I always start with the rule, the code, the statute, whatever, and then I look at the cases afterward.
So tell me why you start with the rule, the code, the statute.
I think we're just kind of trained to do that in law school, and I feel, and also, I mean, just based on what Lexis and Westlaw offer, if you start with the statute, then they show you cases that have cited to it, and
Right.
so it's kind of a way of narrowing the window of research right away.
Right. So statutes and such are primary sources of law, right? And so really that's setting out the primary rule, and then what are the cases doing?
Interpreting, elaborating on.
Exactly. And there will be times when there's conflicts between what the statute, or appear to be conflicts between what the statute is saying and what the case law is saying, right? And so you need to understand that, what their relationship is. What's the limitation in terms of what statutes, constitutional provisions can give you? I mean, could you take, for example, a rule of evidence, or could you take the text of the First Amendment and solve a problem with just that?
No.
Right.
Well, the chances are, especially I feel like when you get to the appellate level, you're not in front of the court unless there's some nuance or ambiguity that they're trying to resolve, or there's at least strategic arguments on both sides. So,
Okay.
Yeah.
Okay. Alexis?
I kind of actually did what Allison did too. I knew that it was a confrontation clause case and that it was higher, but and I even thought to myself that I would like to do confrontation clause first, but because he said to do it second, I just kind of
Absolutely, yeah.
I know this about myself anyways. I kind of tend to get really focused on details instead of taking a step back and looking at the whole thing.
Okay.
So I like to think I know a decent amount about evidence. I'm a research assistant or whatever. So I was kind of like really into it, thinking like, I actually don't think that this is, blah, blah, blah. And I didn't even, what I should have been restricted to was what the case law in this jurisdiction was.
Yes, right.
But
and so that's an important point too, because we're not, the academic approach to law versus a practitioner's approach to law, those are two different things. And as practitioners, especially working for the judge, you're bound by the specific body of law that applies to the case in front of you. And so kind of, again, that's that idea of drawing on background knowledge. Sometimes it's appropriate and sometimes it's not.
So I think, and then I was also really into trying to figure out how to organize it.
Okay.
I wanted to combine, I was trying to find a way that I could write less as far as not having to write the rules twice or applying one or the other. Just pretty much overthought probably on that part too.
Okay, well let's take a look at this together, and we'll look at it with a sort of sample, very ugly, really, sample answer that I wrote, and we'll talk about this in the context both of performance test technique and then also just working with law and working with facts in this sort of microcosm, okay? So obviously the first place you start is with the task memorandum. You're writing a bench memorandum, and I think we talked about this in the first day of class. The purpose of the bench memo is what?
To inform the judge.
Okay, to inform the judge about, prepare the judge for what might be coming up in this case in the evidentiary hearing, and, the legal and factual issues raised by the motion. So at the end of the day, the judge is doing what with this motion?
Using it to brief, just to refresh himself on or herself on the issues in the law, so that when there's the actual motions hearing, she knows what she's doing.
Okay. And then making a decision on the motion one way or the other, right, at the end of the evidentiary hearing. So when the judge says, address the evidentiary issues first and then analyze the constitutional issues, don't mess with that, right? Like when the judge is giving you directions, or whether it's a partner or what have you, and especially in the context of the performance test, you're really being tested on your ability to follow directions or your willingness to follow directions. So, there are times to think outside the box in terms of legal analysis, but they're rare. Those occasions are very, very rare. Okay. So, and then what do you have next in the file?
After the motion?
Right after the task memo.
Just like the format for the bench memo.
Okay. So this is what you want to look at next. This is called an instruction memo. So there's a task, in every PT there's a task memo, and some PTs have an instruction memo. And again, this is about following directions. And so they tell you they want to have, for example, these 3 components. You should go ahead and type that into your document, okay, at that point. So the first 5 minutes of reading this, you have memo to, from, and Ray, your introduction that states the purpose of the memo, and then the 3 sections, statement of the issues, analysis, and recommendation, okay? Any questions about that, or did anyone not really pay attention to that, for example?
Not much I should, I don't think.
Okay.
More of a suggestion.
That's so interesting.
Not an instruction.
That is so interesting. So, chambers work in different ways. Some are more strict and regimented, and others a little bit more flexible, and one of your jobs at going in there is to get a sense of how your chambers works and what your judge's expectations are. But if you think about it, the judge has a rotating cast of characters, typically, anywhere from all the law clerks to a law clerk and a permanent clerk or what have you, staying for 1 year, staying for 2 years. There are protocols in place. And for you to try to alter those protocols is not going to be helpful, right, given the type of work environment that it is. So it is really important to try to get a sense of how have these things been done previously and to conform to that. So typically with a performance test, I recommend skipping the fact file after the task memo and the instruction memo and going directly to the law library, because you really need to understand law before you can start dealing with the facts. But here, you are analyzing this motion, right, and the viability of this motion. So I would at least take a cursory glance at what the motion is alleging, okay? And in fact, after looking at the motion, you could draft your statement of issues. There are 2 types of attacks on 2 pieces of evidence, so basically 4 issues, okay? And the idea being that I'm trying to build my document as I go through this information to sort of maximize efficiency. Not waiting until I've read everything, but once I know, okay, I've got this piece in place, start to incorporate that, okay? Now you get into the nitty-gritty facts, right? And this is the point at which it really does not make sense for you to read the facts in great detail. And I don't know if anybody was kind of inclined to read the facts prior to getting to the law library. But again, whether it's a performance test or whether it's a motion that you're deciding or an opinion that you're drafting, it's very important to understand the applicable legal framework before you really approach the facts, right? So you don't want to, for example, we're going to talk about how to deal with voluminous records. You don't want to go through the entire voluminous record, only to find out that the legal question that you're looking at is actually quite narrow, okay? So really think about the law as the sort of guiding light in terms of your analysis. Now the question is, okay, you have a law library, and I would suggest that you understand the big picture, right, before getting into the details. And it sort of goes to, Alexis, to your point, about kind of getting fixated on that micro level. It's the idea of the forest and the trees, that you really need to be able to conceptualize both to have a full understanding, okay? So let's go ahead and look at the sources of law. So you have the rules of evidence, right? These are the rules that apply in this case. You're not going to take it down word for word, but you can see that you have hearsay, general presumption of exclusion, and exceptions, okay? So that's pretty much all you need to take away from this, is that the rules establish these certain parameters for the issue of hearsay. And then you would note that you have a state Supreme Court decision and a federal Supreme Court decision. So without even reading a United States Supreme Court decision, decision. Without even reading the substance of the cases, what is your best guess as to what they address?
Here's
Two issues.
Which case addresses which issue?
Evidence is for the state, and confrontation is this.
Okay, and I believe, if I remember correctly, yeah, the state court gets into the confrontation clause too, but the state is going to talk, the state court is going to talk about the state rules of evidence. And the federal court is going to talk about the constitutional issues here, all right? So when you see, what is the relationship, we already talked about the relationship between the rules, any kind of statutory or code provisions, and the case law, right? So the rules are the primary source, and the case law elaborates on that and provides meaning and interpretation. What about state Supreme Court decision, United States Supreme Court decision? What are the possible relationships there?
If the U.S. Supreme Court decision says anything that contradicts or overrules a state court decision, U.S. Supreme Court decision is more, well, is the governing law.
Vis-a-vis what?
supremacy.
So how does the supremacy clause operate?
If there's a federal law that's more restrictive than a state law, then the federal law overrides.
Okay, so who has the last word on interpreting federal laws, including the Constitution, the United States Constitution? The federal court is the United States Supreme Court, okay? And so the interpretation of the United States Supreme Court has precedence over any state court interpretations. But a state court might have to take a guess as to how the Supreme Court is going to look at a particular issue if it hasn't looked at it yet. But who's the authority on state law?
State Supreme Court.
State Supreme Courts, okay? So you either have situations where a state Supreme Court has already analyzed an issue and the federal court will defer to that. Or, and this actually is something that happened in the California Proposition 8 litigation, which is what we're going to be looking at, the state court hasn't addressed it, and the federal court might certify the question to the state court to address that, okay? So that's also one of those issues you might be thinking of as a law clerk. You know, do we have the information, if you're working for a federal judge, do we have the information from the state courts that we need here, or do we actually have to perhaps certify this question down to the state court to resolve it, okay?
So we
Go ahead.
have identical language in the federal constitution and the state constitution. Does the state Supreme Court rule on interpretation of those exact words in the state constitution?
Yes. Yes. So it basically depends on what path the state Supreme Court commits itself to, okay? So, you know, for example, there are some certain state constitutions that were enacted before the federal constitution, right? And their language departs radically. So Vermont, for example. And so they have, you know, they're analogs, right? So there's a First Amendment analog, there's, you know, Fourth Amendment analog, but the language is different. So that gives them sort of clear permission to interpret it differently. But then even there's some states where the language is identical, but what is different is the context, right? Or the sort of, you know, the cultural context in that jurisdiction or what have you. So they're bound by the United States Supreme Court's interpretation of the federal Constitution, but not necessarily identical language in their own Constitution. They have some wiggle room. But courts can also decide, and often do, to simply follow United States Supreme Court jurisprudence with respect to language that's identical. So I just want to push back a little bit on this notion that the federal courts always have the last word on legal issues, because there's a set of legal issues in which state courts have the last word, right? And that's interpretation of state law, including the state constitution. And there is a particular circumstance in which, when there's conflict between the federal standard on a particular constitutional issue and state standard, where the state prevails.
I guess I don't know here. I don't understand.
Yeah, that's totally fair. So a state in its constitution cannot deprive its citizens of rights that are guaranteed by the federal constitution. But what can it do?
Give you more.
It can give you more rights, okay? So if you have, and this happens a lot, I'm pretty sure this has happened in Colorado, and I think Colorado has, you know, language that's fairly identical to the federal constitution, but a First Amendment issue. You know, and the federal courts will say, well, you know, X, Y, and Z is sufficient, or this is how much free speech students have in schools. And the state can come in and say, well, actually, we're going to accord more freedom. And so, as between the two sources of law, the state's broader decision is actually the controlling precedent. So it's a little bit more complicated. But whenever you see a state Supreme Court decision and a United States Supreme Court decision, you want to be conscious of the potential for conflict. Okay. So how do you?
So sorry, just back to that point.
Right.
So if there is conflict,
Yep.
then what?
So it depends. I mean, essentially, again,
If the U.S. Supreme Court hasn't full-on overruled, so obviously if a decision gets appealed from state Supreme Court to the U.S. Supreme Court, and they overrule what the state Supreme Court has said,
they can only overrule them on federal grounds, right? So like it could, due process or something like that, right? But they can't say or if a state were to interpret a state law in a way that violates due process or some other federal constitutional provision, and that was actually challenged as part of the litigation, then the United States Supreme Court would be able to have a say on that particular matter.
Okay. Because I was thinking back to Plessy v. Ferguson, and I was like, but that was a state statute, but the Supreme Court looks at it from
Federal Equal Protection Clause.
Okay.
So this is good. So for example, Proposition 8 was challenged in both state and federal court on different grounds. Okay, so Proposition 8 was an amendment to the California Constitution. So it'd be very difficult to argue that a provision of the Constitution violates that same Constitution, right? So the Equal Protection Clause, analog to the Equal Protection Clause, the California Constitution wasn't really available to the litigants there. Instead, they enacted a sort of procedural challenge to how Proposition 8 came about. But then after that litigation, in which they failed, then they went to federal court, which people had very different views about whether that was an appropriate strategy or not to put this up in front of the federal courts and eventually the United States Supreme Court. But at that point, they had a different basis for challenging the law, which was the Federal Equal Protection Clause. Okay, so there's a lot of choices in terms of impact litigation about whether you're going to go for the state court route or the federal court route. A lot of state courts are more protective of individual liberties than the federal courts are. Okay, so coming back to the performance test, what you want to do, and I really like that this point was actually reiterated in the ethical judicial opinion writing article. It applies here and it applies to your writing as a clerk going forward, is that you don't want to either look at cases or talk about cases as cases. What do we get from reading the precedent? What are we trying to extract from the precedent? A story about what happened in that case? No. Why do we read precedent?
Application of the rule.
So that I was going to read the second piece. And the first piece is the articulation of the rule. Okay, so these cases are relevant to us in future scenarios to the extent they provide guidance on the law, and they do that in two ways: by articulating the rules of law, and then showing how those rules can be applied to facts, which may or may not be relevant to our particular case. Okay. And I think this is a little bit different than how you learn to read cases in law school and talk about cases in law school, right? I mean, how would you characterize the way you briefed cases and talked about cases in your first year law school classroom? Allison? You guys don't have to answer. I'm just gonna keep practicing.
How would I characterize it? I would say we really look at the facts a lot.
Yeah.
So really, really dig into that and make sure you've got all the relevant facts.
And what is that? I mean, and how is that different than how a practitioner reads a case, do you think?
I think it's because when you're trying to even understand how these rules work and like the points in the analysis where you should be asking like, well, what if this, what if this, what if this, you have to see like an example of all of it to be able to kind of know how to even spot the issues. And I feel like by the time you become a practitioner, you've got the issue spotting under control and you need to know what to argue.
Right, what does this case stand for, actually? And so in your first year class, you might be kind of acting like the judge, right? So you're sort of looking at the case afresh, what were the facts here, what legal rules applied, how are those rules applied? But when you're a practitioner, including being a law clerk or a judge, you look at the cases not for the story they tell, or the sort of, historical evolution of the law. The cases are precedent. They are decided, unless you have some argument they're wrongly decided, which usually if you're arguing that, you're kind of out on a limb, right? You're looking to them for the rules of law, okay? And that's something that the performance test process really emphasizes, I think, is positive in terms of making that transition to how practitioners read cases, okay? So when you come across a case like this, you want to understand what the basic setting of the case is, but the procedural posture, the decision below, totally irrelevant. Unless you're going to somehow dissect or deconstruct this case for a particular reason, none of that really matters, okay, to use in the case going forward. So when you look at this, you want to go to, essentially skip right to the analysis, and you want to start identifying the rules of law, okay? So it's pretty, straightforward here. It talks about Rule 8032 and really just kind of restates what's in the rule, but more significant is the phrase that starts "in this case," right? That's the here, for example. This is the rule application. This tells you with that sparse text in the rule of evidence how it actually functions and operates with respect to a given fact pattern, okay? So what I advise for you to do with the performance test is to go through the entire law library and identify all those rules and all those rule applications, which are the guidance that the cases are giving you. Okay, don't be selective and go from one issue or the other. Just go through it in sequence. The rules of law, typically, you're going to be quoting those with an attribution to the case. The rule applications, you might find it helpful to summarize or characterize those. Okay. Do you all feel like there's ever any question about, well, is this a rule of law or is this a rule application? How do you tell the difference? How do you tell the difference between a rule statement and a rule application? What are the characteristics? Yes, Kira.
The rule application has facts.
Yeah, specific facts. Okay, and versus the rule.
It's just kind of a general proposition.
Yeah, it's a general standard or principle. And this is something we'll talk about with respect to your writing, but a rule should be a rule for all time, right? A rule should be general enough that it can be applied to other factual circumstances, okay?
Although I guess kind of in between there, if you're analogizing to another case, you have facts, but you're still in kind of your rule explanation part,
Yeah, so people have different ways of describing it, but I would say, right, the rules and the rule applications from the precedent cases are all forms of guidance, but it's a difference between one being a pure abstraction and the other one being an example of how that abstract principle is applied to particular facts, okay? So the court explores, very clearly with, setting out with headings and everything, the excited utterance, dying declaration, and then explains, and let's look at this a little bit more closely, explains how this relates to the Confrontation Clause. So how does this relate to the Confrontation Clause, if you all remember?
Sorry, what's the question exactly?
So how do the hearsay exceptions relate to the Confrontation Clause? What's the interplay of those issues according to the state Supreme Court?
So if it's an excited utterance, solely self-excited utterance, you don't have to do the Confrontation Clause. But if there is a binding declarations argument, then it does require the analysis of the Confrontation Clause.
Does everybody agree?
Just the opposite.
I think,
but
yeah,
not right,
okay.
yeah.
Oops.
What's the justification for this?
Dying declaration was an exception before the Constitution was written, before the Fourth Amendment was written. So, if we're going to have this kind of originalist view of the Fourth Amendment,
Sixth Amendment.
Confrontation Clause. Oh, Sixth
Yeah.
Amendment. Then, then that exception should still survive the Sixth Amendment.
Okay, which really, I think, kind of a weird sort of reasoning and not very intuitive necessarily, but it's critical that you take that away from this case, right? So, and that's based on not this court's interpretation, but you mentioned which case?
Crawford,
Which is which court?
the Supreme Court.
Okay, so now you're thinking, what as you go to read the Supreme Court decision? What are you wondering?
Thinking this is an odd. The state Supreme Court is really certain about
What's later?
an exception that's not certain at all. But
Well, what's part of the reason why it's not certain? What part of the,
well, I
technically
mean,
speaking, what part of the Supreme Court decision was this in?
well, it was in dicta in Crawford that you had, they're discussing the dying declaration. And then in the case they have, Michigan v. Bryant, there was the dissent that said, dying declaration wasn't preserved for appeal, and we'd like to rule on it someday, but we haven't yet. So then it's, I don't know, it's just weird to have the state Supreme Court being like, well, this is, I guess they have to come down.
But that's the
one way-
situation that-
They have to come down one way or the other.
Yeah,
in the
oftentimes
meantime,
the
yeah.
the state Supreme Courts are sort of reading the tea leaves about what the United States Supreme Court means, okay?
Yeah.
And actually, another circumstance where you see this come up, with all the DOMA litigation, so there are these two parallel same-sex marriage challenges before the United States Supreme Court. One is just California Proposition 8, went up through the Ninth Circuit, is in front of the Supreme Court. The other is the challenge to the Federal Defense of Marriage Act, which was litigated in a number of different federal courts, and they accepted search warrant of one of those. But there's a number of different federal district court and federal circuit court of appeals decisions on the issue. And one of the things they're doing is saying, they're trying to speculate as to whether the United States Supreme Court will recognize sexual orientation as a suspect class. Okay, so when the courts, lower courts, be they state or federal, are in a situation where they don't know, where they don't have clear guidance from the court, they're kind of, like I said, reading the tea leaves, seeing what the court has said, and trying to make sense of that. Okay, Alexis, any thoughts on that?
Yeah. No.
You're angry. Oh no, you
No, I
agree.
agree.
Okay.
So I'm wondering, with that said, so it's like,
Guess what?
the state has come up with their own clarification of how they're gonna apply
Yep.
the Confrontation Clause to these evidentiary rules.
Yep. Until they hear otherwise, right?
Right, and so then we get to the Supreme Court case, and they kind of say that they've left it open.
Yeah. So,
To
and
the
that's
state,
that's
so-
what you want to sort of latch onto, right? So I'm thinking, well, the Supreme Court case, they're going to make this interesting because the Supreme Court is now going to pronounce something different on the whole issue of the relationship between dying declaration and
Oh,
confrontation
thanks
clause.
for bringing us back to that
Yes.
question. I couldn't remember where we started.
Yeah, no. Right, so you're looking to the Supreme Court, and that's what I was looking for when I was reading this, and what happens, in fact?
Yeah. So I mean, you're kind of.
What happens in the Supreme Court decision?
Really recall, but.
In the U.S. Supreme Court?
Sorry, thank you, yeah. What does the court have to, what is the body of this opinion about? To the extent you can discern it, because it's,
The ongoing emergency exception.
Yeah.
okay. So this is really about go ahead.
Whether or not it's testimonial. And then, so it kind of defines that analysis for the Confrontation Clause that you have to go through to determine whether or not it's testimonial or not.
So this is all within that little segment of the Confrontation Clause analysis. Okay, so the state court decision tells you about the state court interpretation of the state rules of evidence and then how that intersects with the Confrontation Clause. And the body of this opinion, its function is to tell you how the Confrontation Clause analysis works with this testimonial versus non-testimonial issue. But there is a commentary on the dying declaration relationship to the Confrontation Clause where? In the opinion.
In the Supreme Court? Oh, I don't know.
Where the dying declaration in footnote 1.
Yes. And this really, for me, I mean, I often say that the lessons we learn the best are ones that arise out of humiliation. And just first year in law school, I think it was, Carolee Products. I didn't read the footnote because why would you, right? And, it became evident that footnotes are sometimes important. So what's the footnote saying here, Kira?
So it's saying that there is in Crawford where,
No, it's
dying
okay.
declarations, even if testimonial, might be admissible as a historical exception to the Confrontation Clause.
And So what did the state court, the underlying court here, do with this argument? This is a nice little piece of procedural maneuvering or reasoning.
Of Michigan or French?
Michigan, sorry, yeah.
They kind of disposed of the dying declaration argument because they said the party didn't preserve it, so they only ruled on the excited utterance.
Okay. So from a procedural perspective, because the state court didn't engage the issue, the Supreme Court's not going to engage the issue, and well, you really don't want to write a whole judicial opinion that addresses an issue that wasn't preserved below. Okay, so that's one of the issues we'll talk about, because should the opposing party catch that and brief it that the issue wasn't preserved? Yes. Do they always? No. So one of the things you want to always assure yourselves of is that the issue was actually preserved to be addressed, okay?
So otherwise you're issuing like an advisory opinion from you.
And that comes down to, Article 3, role of the courts. The courts do not, our courts do not issue advisory opinions. They do in other countries, but not in the United States. And the whole, case or controversy sort of discursive process underlying that theory. So
What happens when a court does that? I mean, is it just another appealable issue, or? I mean, if it's kind of outside of the issues, how's that handled?
outside the issues that were raised by the parties?
raised or
Well, so this comes into something I want to talk to you guys about with respect to the article, but there are two different types of courts, essentially. There's sort of courts that want to reach the right decision no matter what,
Right.
and then courts that, if the parties didn't raise it, they're not going to address it. So the 10th Circuit was that latter type.
Right.
Okay, if the parties didn't raise the issue, they weren't going to address it. The Vermont Supreme Court would reach out and grab any issue it wanted to, if
Okay.
it thought it was reaching the right decision. And that's partly, the culture of the court, or what have you. I mean, one of the things the court can do is seek supplemental briefing on a particular issue if the court wants to address it. But is there a possibility for someone to appeal and say, well, this was an advisory opinion, violated Article 3? I've never seen it.
Yeah, I don't know if
Yeah.
it's an argument either.
Yeah, I've never seen it. I mean, maybe just because judges are trained to, really only address issues that are at least raised by the record and arguably have been.
I guess there's not really any harm.
Of course there
I
is.
guess there is.
According to the Constitution, what's the harm of advisory opinions? Potentially, at
Well,
least.
well, state court, so state court isn't bound by that.
No.
I think it
So
comes
state courts
from-
do have different approaches to the issue of advisory opinions.
I mean, it's not right. But, beyond that, I'm not sure what the specific harm would be.
Is it separation of powers? The judiciary is overstepping their jurisdiction?
Yeah, so that's definitely part of the issue of separation of powers, right? So prospective laws based on policies and things are like really the province of the legislature, right? And courts are supposed to only decide actual cases or controversies. What's the chance of a court reaching the right decision?
If you don't have all the facts, and the whole thing behind a case is right that what is it that the parties are interested parties, so they'll be zealous advocates.
Yes.
If they're not, then you don't know. You might not have all the facts. It might not.
All
be
the
well
arguments, all the
developed,
ideas,
the-
right? So that sort of adversarial process being key to reaching the best answer, and that's sort of this discursive democracy idea, okay? I love the tangents we get onto, and then I'm like, what are we talking about? So the Supreme Court punted, right? It said, we're in a posture to reconsider this dicta from Crawford, and so this lower courts are free to continue to interpret the way that they have, okay? And so that could you solve this problem without recognizing that that's what happened? Maybe, but you really need that certainty that this is still, the state Supreme Court, its interpretation of what the United States Supreme Court was saying still holds true, because the United States Supreme Court hasn't said anything affirmative to contradict that. Okay? So let's try to wrap this up here. But so even when you have a relatively complicated, multi-issue PT like this, the principle is the same, and it does translate to your other work as well, which is to first understand the law. And that means understanding the relationship between statutory provisions and the case law, and then extracting only those parts of the cases that are really helpful to you, which are the rules and the rule applications. So what's happening in the sample answer is, first of all, I listed evidentiary issues and then constitutional issues 1 and 2, because that's what the judge told me that he or she wanted. And then essentially listing all the rules of law that I find in the cases, all of them, not trying to distinguish between which ones are relevant and which ones are not relevant, or more important or less important. And then going to the fact file and incorporating the application. Okay? So, for example, if you look under excited utterance, first mention the rule, right? Then discuss what the cases had to say about the excited utterance rule. And then switching over to the application. Okay, so if you very sort of sequentially approach the materials, where you first extract the law, then organize it to some extent, and then go to the facts and apply it, you're going to have a lot easier time solving the problem. One of the issues people run into is just trying to solve the problem way too early. Okay, you really need to have a full understanding of the legal framework before you can move forward. And that's how you were able to complete a work product, in 90 minutes. Okay. So any realizations or questions kind of coming out of that review?
I know you mentioned that you thought this MPT was harder than other ones.
Yeah.
Do you have data on when it was administered for the bar, for people scoring much lower than other years?
I don't have data on that, and it also depends, because the Colorado Board of Bar Examiners, they score these. The NCBE drafts them, but they don't score them.
Okay.
So the contention of the NCBE is that all the PTs are of equal difficulty, which I think is kind of doubtful. But you do see when the Colorado Board of Bar Examiners used to give full point ranges, you would see some PTs were up around 18 points average score, others were down by 11. But the key thing to remember as far as bar exam performance is that it's relative to everybody else in the room and how they're doing, right? And especially now that Colorado has a 6-point scoring system. They used to have these elaborate point sheets that could be up to 30 or 40 points, and now they're doing all the PTs and the essays on a 6-point system. So the best in their stack of 30 goes into pile 6.
Oh, I didn't know that. I
Yeah,
thought
they
you
just
got
this
your
summer
score.
or this February is the first time they're applying this.
Oh.
So it's kind of freaky. So you really are being judged relative to your peers. So you guys are all going to do better than most people.
Yes.
So that, to the extent that that's comforting. I mean, if you imagine somebody hasn't practiced the performance test, and a lot of people don't, they come across this, it's going to be a little rough. Okay, so you guys are going to be in good shape. That's one of the great things that the Bar Success Program does. It really preps you for the performance test stuff. Okay, so again, just trying to kind of, get our juices flowing in terms of writing and analysis, give us something to talk about, let you think about the bar exam a little bit, and that's the only, the extent to which you should be concerned about this particular problem. So let me go ahead and collect those packets and the sample answers again.
Didn't give you the sample answers back?
Yes.
Oh, sorry, I'm running late.
That's fine.
I didn't write anything.
Yeah, you were kind of asking for realizations, and I think
Yeah.
part of it's I kind of got the main law or the statutory law in there,
Yeah.
but then the rules of law I don't think I did as well with.
Okay.
I just kind of went straight to an application
Okay.
of trying to incorporate the facts of the case into the rule of law.
Okay.
Without
And what's the
separating
pitfall there?
It looks like you don't recognize the rule of law.
Yeah.
You're kind of mushing things together.
Right.
Potentially missing other rules of law.
Right. I mean, because the courts have done it for you, right? So there's nothing new under the sun. When you guys, especially if you're sitting there as a law clerk writing a judicial opinion, you're going to have models, some of them better, some of them worse, of analyzing the same issues. So ineffective assistance of counsel, right? Two-prong approach. Was performance below standard of a reasonable attorney, whatever it is, and did prejudice result, right? That is going to look the same. The facts will change, but that essentially is going to be the same structure, for every time that you analyze it. And sometimes people, especially people who are good writers or who are creatives, are bothered by these recurring patterns in judicial opinions and legal analysis, but that actually serves this function of predictability and making the law accessible and predictable, which is a very important, sort of justice function of the law. So, yeah, someone's done it before. Look at how they've analyzed it, what considerations came up for them. That's all a form of guidance for you in working on that. Okay, so let's talk about the reading on sort of ethical standards that apply to judges. And the first thing I would like for you guys to do is actually, each of you come up to the boards here. And the articles are kind of broken into two parts. So one really goes to conduct outside of writing, and then the other goes to ethical considerations in connection with writing. And so actually, Will, why don't you be the scribe, because we only have one pen.
Okay.
And then the rest of you, let's brainstorm some of the ethical standards concerns that apply to conduct for judges, right?
Appearance of impropriety, is that what you mean, or?
Uh-huh, exactly, yep. So what about the appearance of impropriety? Is that to be sought after?
Avoided.
Avoided, okay. What's the difference between impropriety and the appearance of impropriety?
Actual or what it looks like it.
Okay. And why do we care about the appearance of impropriety even if there's no underlying impropriety?
Because we want people to think that the judicial system is fair, just, reliable, that neutral. So
Okay.
any appearance of impropriety what did they say there? Like call that into doubt, basically.
Okay. So that all goes towards upholding the legitimacy of the judicial branch. And if you think about your own potential situations, what's the difference between adhering to a standard of avoiding impropriety versus adhering to a standard of avoiding the appearance of impropriety?
You could be like, we could know like one of the parties from law school, and you could be like talking to them after the hearing about like, your favorite band or something, but if the other party sees you, then like Alexis was saying, it calls it into question, but there's a difference because you could totally be doing nothing wrong, but it looks like there could be something improper.
Okay, great. So it's a much higher standard, right? So you need to not just think about why am I doing something that's questionable, but how would it look to an outside person? Okay, what else? Anything in these standards that surprised you?
I think some of the things that people were excited for or surprised.
I always looked at the date.
Shock.
I always
Right,
wondered
it's
if
like,
people went to law
93,
school.
and
There's a lot from the 90s in like New York and Florida for some reason.
So what were,
There was one judge in particular that got cited like 8 times.
Yeah, it was all
I
good.
think it's all the same case, but like he did lots of bad things.
Yeah, well, there's maybe some argument there about the difference. I don't know if Florida elects their judges, but a lot of other states do, but between elected judges and appointed judges, because there's really different disposition, I would say, in approaching the bench, right? So what were the ethical standards that some of those examples related to? And you can also participate, you don't just have to write.
How they treated like staff or lawyers, or like the respect in the courtroom.
Okay, so what standard would you put that under?
Once again, well, it wasn't quite like an avoid the appearance.
It's not exactly that, yeah.
But it's
different.
actually a direct application. Like don't actually enter into that type of conduct.
Okay. Come up with a phrase to describe it.
Rude and abusive behavior.
Correct demeanor.
Okay. So one catch-all phrase that applies to a lot of this is the idea of decorum. Okay, which I don't know if that's a phrase that you guys are familiar with, but you can put that up there. Decorum, tell me, what does decorum mean? In the context of judicial ethics.
I think both the judge being polite and courteous to all parties, and also making sure that everyone who's in his courtroom or her courtroom is doing the same. So just a certain level of like formality and politeness that goes along with
Why is it important for judges versus other people?
Because they kind of set the tone, I would say, with how, whether people are inclined to abide by the rules of the court or not.
Okay. So
based
they're
on the
modeling
judge.
things like civility, right? What else?
Well, again, because they're supposed to be seen as neutral
Mm-hmm.
or unbiased decision makers, and if there's kind of going back to the impropriety of their, calling one party an idiot or something like that, then they're clearly not unbiased.
Okay, so impartiality is another one you could throw up there. And go ahead, what did you say, Will?
Well, yeah, their bias might come through either against like the parties themselves or a certain generalization or stereotype as well.
Okay, good. So, right, so there's sort of that interpersonal bias, but also prejudicial thinking, right? Okay. What else? There's been some news coverage of this idea lately. A certain justice of the Supreme Court, perhaps, speaking out of turn about pending issues.
When Scalia speaking about gay rights, when he was going to
What I think he said something like gay rights are laughable or
and
something.
he compared it to like homicide, or he compared.
Yeah,
Yeah.
yeah. So what does that fall under?
Ex parte communications?
Not quite.
Or, sorry, saying things, something. Well, that would be like
Personal
an official
bias?
statement.
Exactly, they aren't supposed to speak to cases that could appear before them.
Yes.
Sitting on the Supreme Court,
Okay.
obviously that's going to come before them.
Okay, so this is public discussion of legal issues that are either pending before the court or that might come before the court. And part of the point here too, I mean, these all filter down to you as law clerks, right? So you're coming from law school, you're used to talking about everything with your colleagues and your peers. You can't, especially in Colorado, you cannot go out to a bar and talk about a pending case. You can't tell your boyfriend or girlfriend about a pending case or how the judges are reaching a decision or what have you. Okay, and why is that? Is it about sort of secrecy or what's the reasoning behind that?
Well, you don't know who that person knows sometimes or who's sitting around you.
Mm-hmm.
So it could lead back to some of the parties.
So and that's just generally true, and just as an attorney, in addition to being a law clerk or a judge, that this is a tiny legal community, and you really can't talk about confidential matters. But there's sort of this idea that you're not supposed to reveal the process the court goes through. What's that all about? It seems kind of anti-democratic in some ways.
Is it going back to just like the neutral stance of the courts? I mean, if you start saying like I'm always going to rule this way,
Right.
then it's, you're not really getting a fresh look at a case. It's,
Right.
It's that bias, and you can the lawyers can frame their arguments a certain way to appeal to certain biases and
Right.
opinions of judges.
Right. The judges are supposed to be these almost sort of like, non-human cognitive beings, right? Who are not influenced by the sort of passions that we as regular people are influenced by. And I think it's a productive mythology in a lot of ways, but it's also kind of unrealistic. And I think sometimes it cloaks the extent to which personal bias, inevitably comes into the judging process. But again, it's about the importance of the public believing in the judicial process as a fair process that's sort of governed by rules and procedures and not by individual considerations. Tell me more about ex parte communications, Allison. What's the principle? What's the idea there?
That the judge could either get some information that the litigating parties haven't put before them, or do their own research, or basically gather information outside the process that's already in place for them to obtain it, and that could be unfair to one party or another.
So those are two different ideas, right? One is the idea of contacting attorneys or parties involved in the case, which again goes to kind of bias and impartiality. But this idea of independent research, why is it problematic for a judge to do independent research?
Because it might not be accurate, you might not get full information. They could use it to, if they did have personal bias, to affirm whatever their biases are.
Yeah, there's this idea that the case, especially when you get to the appellate level and you have a record, is this kind of closed box, right? And that this is the arena in which the sort of contest of ideas and facts takes place. And that to look outside of that is to somehow, upset the balance of that adversarial process, okay? Anything else? Anything that you could see affecting you as a law clerk?
Politics.
Okay, go ahead, talk about
You
that.
can't be involved, or you can't advocate for one party or another, or raise money, or attend events, or anything like that.
Okay. Not just for political candidates, but also charities, right? The fundraising thing, did that surprise anybody? No, I can't
Charities
be,
it did, yeah.
yeah, I can't be the sort of honorary co-chair of, fundraiser for anyone. And that's because of the judge essentially asking for money, right? The judge is not supposed to be asking for money. But also, like when I was in the 10th Circuit, I was on the board of mayoral and I had to step down from that because, even though the chances of me working on some kind of abortion relay case were very slim, it's sort of this idea that you have to be above the fray of politics in terms of both candidates and any particular issues that might come up.
I have a question. What if the organization, political or charitable or otherwise, has no idea what you do and has no reason to believe that you're a law clerk and you've never said anything? Like, the only example I could think of, and I don't really know an organization like this, but if you were in some kind of like addiction counseling like group or whatever, where like you keep personal details out, like is that still? Do they have to know of
Or
your
Dumb
role?
Friends League, or
Yeah, do people have to know of your role, or is it just
Kira,
the
I'm gonna
existence of your role no matter what?
punt this to you.
Why?
You were talking about it a little bit before.
Why?
So the idea is that, what's the premise underlying that question is that, okay, if the Denver Dumb Friends League doesn't know that I'm a judge or a law clerk, and I'm helping them out, writing a fundraising letter or something like that.
Oh, is it the appearance
Yes.
of impropriety?
Yeah.
That even
Yeah.
if the Denver Dumb
Oh,
Friends League
okay.
doesn't know, the opposing party might be
Yes.
like, Allison, that's like Justice Hobbs Clark. Or
Okay.
Yeah. So it's really, you're thinking about this reasonable person out there who would think about that and say, that's kind of problematic.
So if you don't sign your name. Sorry, I'm just really curious about this.
Well, because you assume that everything will be found out. You assume that everything will be
Yeah,
found out.
okay.
I mean, that's a good principle to go by in general. Go ahead.
So the standard isn't like a strict liability or like a knowledge or any kind of mens rea, it's an objective,
Yeah.
reasonable person.
Yep.
So it's almost like you possibly could be involved.
What if you ghostwrite something?
No!
No, okay.
I'm glad we're talking about this.
Well, I was just thinking, because I could see people being like, okay, you're a lawyer, like, you understand how this campaign finance rule works, like, will you ghostwrite something?
Yeah. And so I think, and you guys will go through more training kind of related to this, but assume.
I haven't taken LP yet, I'm just taking it right now.
This was what they said to us the first day of law school, which I thought was ridiculous, but they said, don't do anything you wouldn't want to see on the front page of the New York Times. But basically, assume that everything you do could be on the front page of the New York Times. And that's, for you, that's a year or 2 years. For judges, that's for life, if they're, have life tenure. And that's often why judges are very isolated people and really enjoy being able to talk to their law clerks. It depends, on the individual. But, it's sort of, in some ways it feels a little bit ridiculous, right? Like, well, how important am I? But you're part of the judicial system. You're part of the system that resolves disputes in our society. And that's an incredibly important role. And so you have to kind of go beyond thinking, well, I'm just a law student who likes to volunteer for the Dumb Friends League, and really think about it from the perspective of these standards. The appearance of impropriety and the assumption that every single piece of information about what you do will come out. There was a huge issue at the Vermont Supreme Court about, what was it? I think there was a staff attorney who wanted to wear earrings that were like the female sign, like 2 female signs or whatever. It's like, said lesbians are okay or something like that. And the judges wanted her to not even broadcast that. So, and if they're legitimate.
She was wearing them at Work or
At
not
work.
at work?
At work.
Oh, okay.
And I think there might have been like a bumper sticker on a car issue too. And so it's I think it's pretty non-intuitive that, you're not even the judge, right? You're the law clerk. But the judges take this very seriously. Okay, so it is a different way of thinking about yourself and that's what I think is interesting about the ethical standards is the extent to which it affects non-work related conduct. It's something to keep in mind. So.
I mean, the code of judicial conduct isn't necessarily like imputed to all clerks, is it? I mean, but at the same time, if our judge is bound by him, I'm sure he's going to want us to be kind of.
Yeah, I mean,
I wondered that too. Is it
Yeah.
exactly the same for clerks? Or
Yeah.
is it-
So can we not donate to it or like be involved? I mean, is it
in
as?
political organizations now. Yeah, I mean, there might be some variation. I'm wondering how we could possibly, because that is my understanding, that it is actually all imputed to law clerks and staff attorneys.
Okay.
And to staff to some extent. But I'm wondering how we could, does somebody want to take up the issue of researching that?
Where would you look for
I don't know.
And does it apply to interns? Because I've definitely interned for judges and been.
I think
involved in
it
politics.
should, but I don't know that it's ever really brought up. And interns aren't brought into the fold. Like,
Right.
we used to have a lot of rules at the Vermont Supreme Court that interns couldn't sit in on case conferences and things like that. So they weren't, they were kind of kept on the outside of certain
Right.
information. But why don't each of you just try to think of a way to research that, and I'll think about that too. But it's my understanding, and always sort of the way that I was treated by the judges that I worked with, that all the codes of judicial conduct were imputed to law clerks and staff attorneys.
Okay.
Okay?
It makes me feel like you should go through some kind of like ceremonious entry into this, legal, or this, to this
Yeah.
license or
Yeah.
this other code.
Yeah, well, you will be trained either by the
Very
clerk that you're
thorough
replacing,
Yeah.
or there, are other training programs, but to take an oath or something like that.
Right.
Yeah, gosh, this has been a while. I'm trying to remember if I did that, but I think that's, it's fair to assume that actually might happen. Because it's, especially, when you work in a law firm and stuff like that too, the idea of just confidentiality is really, it's tough, because I don't think that necessarily the sort of systems are in place to monitor confidentiality issues and conflict issues the way that they should be monitored, but it's pretty serious stuff. And then you have the other layer on top of this with the role of the judiciary. So.
I've actually been wondering a lot about this stuff. In my offer letter from Justice Hobbs, one of the sentences in one of the paragraphs was like, of course, your discretion, like while you work on the court and for a long time thereafter, is
Yeah.
like really important or something like that. And I was like, ooh, I wonder what that means. But I need to get in there and ask.
Well, yeah, there's a lot of stuff that you all will be kind of acculturated to over time, but sort of the idea that you don't write opinions, you draft opinions. And that, you don't ever talk about writing opinions, you don't talk about internal discussions on the court and the decision-making process. And there's a lot of buy-in there, because your judge's reputation is tied to your reputation going forward. So, whether all of these rules and sort of approaches are really necessitated by ethical standards, I think is up to some discussion, but it's good to flag for you now. I'm sure there will be a lot of messaging around this as you start your jobs, but it's good to flag for you now that there might be sort of ethical and propriety concerns that are maybe not totally intuitive. Okay? Yeah.
And what about the financial
Bill.
stuff, like individual stocks that a clerk owns? Like,
Yeah.
you know what I mean? Like the judge probably shouldn't have those things, but does that really? I don't know.
See, I feel that's up for debate.
Do I need to sell Google stuff before I start my clerkship?
Well, so first of all, right, it would have to be the motion for recusal or, self-recusal based on that. And there's very, precise standards for whether it's a sufficient interest, like if it's part of your stock portfolio, not necessarily. But it's, we definitely need to look at this question of whether every single rule is imputed. And then it's also, a lot of it is up to your judge. Your judge may have strong feelings about that. But for example, with the whole NARAL member or board member thing, the judges on the 10th Circuit had different views, and it was sort of a matter of dialogue among them. It wasn't a cut and dry issue. So I think a lot of it is a matter of interpretation or preference.
Can I lead you astray just a little bit?
Yeah, that's fine.
Okay.
I'll hand out one other thing
Okay.
to just start thinking about our next conversation.
What was
But
that?
I know time flies.
So I did this client counseling competition over the weekend.
Yeah.
And the first fact pattern was a federal law clerk who was fired by her judge. She had been involved in some political activities.
Yeah.
And was fired by the judge. It was unclear, and nobody seemed to know, like, are there, especially for federal law clerks, are there any job protections that are analogous to, you're just there at the pleasure of the judge and you have no protections, really?
Just like any other job.
Yeah, at will.
But I mean, but that would make you different than other federal employees, right? I mean, because if you're a
Right,
civil
it depends.
servant, there's a just cause
Right.
requirement, but then does that not apply to law clerks? Is
Well,
it to other?
it does not, as far as I know, and I'm not an employment law attorney by any stretch of the imagination, but it's the job description and the job category are really different than like a lifetime civil servant or something like that.
Mhm.
Right. So, I mean, as I understand, there's a lot of discretion that judges have. Now, I haven't typically heard stories about judges firing clerks during the middle of a term, but with the level of trust that has to exist in that relationship,
Right.
you know,
You
you
become
want them to have
useless
more
to the
prerogative.
judge if they can't trust you.
Yeah, absolutely. So, how did you do in the competition?
We won, actually. We have to fly to Houston,
That's
Texas.
great.
this month.
That's
So
great.
Could we go on somewhere else?
Very good, very good. Well, let us know if we find out the answer, okay?
Okay.
Okay. So let's just take a quick look at this. I love this quote, and this relates to the ethical judicial opinion writing article, which we'll discuss next time in conjunction with the two cases. There's a line in here, where is it? It is more time-consuming and difficult to write an accurate and effective opinion understandable to laypersons than one that is unintelligible. Takes a lot more effort, right? But there are many, many reasons why it's important as a matter of justice, a matter of ethics, to actually write opinions that are fairly transparent and fairly accessible. And one of the things I really like about this article is that, you've probably learned all this stuff in the first year lawyering process about how to write and plain language and being concise, but this article talks about the connection between style and substance and the role of the judiciary, which I think gives you a lot stronger motivation to want to write in a way that is accessible to the people who are going to be reading the opinion. So our conversation went a little bit longer than expected today, so I'll try to kind of lead us sort of more in lockstep through the discussion on Monday, but for Monday you want to, this is something you could distill down to a page or two of notes, and I think it's just really great stuff to think about as you go into your clerkship. So just kind of review the points that are raised in this article, and then what I'm going to ask you to do is we're going to do a little writing exercise about, at least about Plessy and potentially about Bowers, whether those are ethical opinions, whether there's an ethical flaw in those opinions or not, and sort of, what standards do you use to support that argument, what passages from the opinion. Okay, so great discussion, guys. Thank you.
It might be interesting to have like current clerks come in, how we're
Yes.
talking about having judges, and they can
Yes.
maybe tell us like what they talk about over training, like our question about like does all this stuff apply to us, and they can kind of like tell us about things that they've encountered that maybe they weren't briefed on.
That's great, because they have the clerk's eye view, and they've gone through it really recently. So, might be able to do current clerks or recent former law clerks, and we'll definitely look into that.
Okay.
Okay,
Thanks.
great,
Thanks.
thanks.
Did you know Justice Allen of the Vermont Supreme Court? I don't know when
was
he was
he
there, but his son is a one out here.
You're kidding.
Oh, it was
What's his first, the judge's first name?
from 1 hour.
I don't know. He's my
That we
friend's
wanted to find an
roommate. I'll ask.
excuse to
I'll
do
find
one of
out.
these things.
I don't feel
This thing Saturday, it's like. all
like he was there when I was there.
And,
It
so
was,
wasn't-
That's not even fair.
So Justice Johnson, Justice Scalia, Justice Dooley,
I don't feel like.
and the Chief Justices changed it when I was there.
That's what I felt like, but thank you.
You know who I think would be good?
Tell me.
Oh, Kevin McAdam.
Okay.
I can send you his contact information.
Will you do
He used to
that?
work for Wales Clerk.
That'd be
He was
great.
because we both interned for her.
That'd be
And,
great.
he was really helpful.
Yeah.
And
That's
always really
definitely-
honest.
Yeah.
And outgoing and.
Okay.
I'll send you the name of other clerks.
Yeah, because you guys are more, I mean, I can talk to the people in CDO and stuff,
Alex
but.
Clark.